Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Well, in the national news is President Trump's decision or his intention to end birthright citizenship by executive order. We talked about it yesterday. We'll talk a little bit more about it today. President Trump says he plans to end birthright citizenship by executive order. This is a long overdue and much needed reform to our nation's immigration system. The president is attempting to correct a century-old abuse of the rule of law. And America will finally join just about every other advanced nation in the world. The president is correct. The U.S. Constitution does not confer automatic citizenship upon babies born in the U.S. soil to illegal alien mothers. Birthright citizenship is a purported right created by activist federal judges out of whole cloth. This judicially created right has incentivized an entire birth tourism industry where pregnant mothers fly in from China or wade across the Rio Grande just to give birth in the U.S. Once their children reach the age of 21, they can petition for immigrant status for their parents, who now move to the front of the line due to the family reunification preference. That's why these children are sometimes referred to as anchor babies. They give their parents an anchor into U.S. citizenship. A study from the Center for Immigration Studies concluded anywhere from 300,000 to 400,000 anchor babies are born in the U.S. each year. That's 7,000 times the population of the city of Harrisburg. The Congressional Budget Office estimates there are now 4.5 million anchor babies in the U.S. as citizens. That's more than the number of children born each year to U.S. citizen parents. This is a massive demographic change in the composition of the United States, which U.S. voters have had no say over. Well, how did this come about? Advocates of birthright citizenship point to the 1898 case, United States v. Wong Kim Ark, which held the 14th Amendment to the U.S. Constitution, adopted the British common law definition of birthright citizenship, and that a child born in the U.S. to Chinese parents who are lawful U.S. residents is a U.S. citizen at birth. But not only did this case not involve parents who were in the U.S. unlawfully, it also rejected the social compact theory of citizenship of our founding fathers. America was founded upon natural law, which rejects the definition of birthright citizenship practiced by feudal societies. Our founders determined citizenship not solely by the location of birth, but by the consent of those within the social compact as well. That's why Indians and blacks did not become automatic U.S. citizens merely by being born on U.S. soil. Further, the court in Wong Kim Ark ignored its own precedent. In 1884's Elk v. Wilkins, after examining that very same 14th Amendment, it denied U.S. citizenship to an Indian because even though he was born on U.S. soil and had severed his tribal relations, the U.S. had not accepted his surrender or in any way recognized or treated him as a citizen. The Elk v. Wilkins court interpreted the 14th Amendment correctly. Well, what does the 14th Amendment say exactly? First, this amendment had nothing to do with granting citizenship to foreign babies born in the U.S. It was about preventing southern states from denying citizenship to newly freed slaves. Second, its text reveals it incorporates the natural law theory of citizenship. It states all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the U.S. Pause on that for just one moment. If a person who is born in the U.S. is automatically and without more a U.S. citizen, then why include the second clause? The second clause, the subject to the jurisdiction thereof, is not about territory. That's defined in the first clause. Jurisdiction in this context means political allegiance. During floor debate in Congress on the bill, its principal drafter defined the clause as not owing allegiance to anybody else. Another said it explicitly excludes from citizenship persons born in the U.S. who are foreigners, aliens, or who belong to the families of ambassadors or foreign ministers. That's because those persons owe allegiance to a foreign nation, and the U.S. has not accepted them as citizens. This means a pregnant woman who crosses the Rio Grande and illegally enters the U.S. and gives birth to a child here does not confer U.S. citizenship upon her baby. That baby is a citizen of Mexico, not a citizen of the U.S. That's because his mother, even though on U.S. soil, is still a foreigner, or as she's defined in U.S. immigration law, an illegal alien. The U.S. has not accepted her purported surrender of political allegiance from the Estados Unidos Mexicanos, that is Mexico. Importantly, the American people, and not this Mexican woman, have the right to decide whether to accept her and her baby into our social compact. Whether the president has the power to end birthright citizenship by executive order is a story for another day. In the meantime, the president should be commended for attempting to correct this misinterpretation of U.S. immigration and naturalization law. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening, and enjoy your lunch.